Today, the Supreme Court of Canada struck down a law that automatically puts sex offenders on the National Registry for life. It was first brought in by then Prime Minister Stephen Harper. Canada's top court ruled in a 5-4 split that it was unconstitutional to automatically register those convicted to 2 or more sex offenses if they are not, quote, in increased risk of reoffending. Today's court decision means offenders who registered after 2011 can appeal to have their status changed. To break it all down, let's bring in criminal defense lawyer and legal analyst Ari Goldkind. Welcome to the show. First, why was this provision of the criminal code deemed unconstitutional?
So, Mike, this is a really interesting case, and the headline should not be what they will inevitably later, which is the Supreme Court goes light on sex offenders or cuts them a break. This is a Supreme Court that is notoriously difficult on accused or convicted people charged or convicted with sex offenses. If you're an accused and you go to the Supreme Court to appeal, you lose 34 to 35 to 0. So nobody should take that takeaway. What the Supreme Court said, and this is the key to the decision, if there's no intervening act, if, for example, you're an 18 or 19-year-old at a party, maybe you've had a bit too much to drink, and you touch the buttocks or the breast of 2 people at the party, you would have been sentenced to the sex offender registry for life. Judges did not have discretion. It was taken away. And the intervening act part is important. We're not talking Paul Bernardo here, where it's not as if you were told not to do something and then you went and did it again 2 years later. So remember that 18 or 19-year-old example. And the Supreme Court said that if the purpose of the sex offender registry is to help police find sex offenders, to solve those crimes, if the person we're talking about here is not thought by anybody, and I mean this very clearly, not thought by anybody, particularly the judge, to be at a risk to reoffend going forward, it is almost akin to cruel and unusual punishment, to use a term from the Supreme Court in a previous case, to label them a sex offender on the registry for life, which, without getting too far into the details, decimates somebody's ability to get a job, travel, move around, live where they want to live. It is almost a sentence, Mike, much, much harder than the 30, 60 days in jail, 6 months in jail that they would have otherwise received.
All right, I've got 20 seconds left. Should Canadians be worried about this effort now that some people can take to get their names off that list? Or is it, as you were saying, this is only applying to certain people here?
No Canadian should be worried at all that this opens the floodgates to anything, or that this means that Paul Bernardo, like sex offenders, rapists, will catch a break. That is not what today's decision is about. No headline should go out on anti-social media about this. This was the Supreme Court saying, look, if you're going to punish people, do it in a constitutional way. And oh, by the way, let judges who know the case is best, let them exercise their discretion when it is fit to do so.
Legal expert Ari Goldkind, thank you so much for taking the time and breaking it all down for us. We're going to have to leave it there.